And next I'm going to talk about access to confidential company documents, particularly in the context of self-help. And what I mean by self-help is where you have an employee who may feel they have a claim of discrimination or retaliation against the company. Particularly, you may have an employee who is gathering up emails, making copies of documents and those types of things. And can an employee take those and take them with them? Bring them home, give them to an attorney, disseminate them. That's what we're really talking about here. And what the law has determined is that with regard to self-help, self-help can be a protected activity under the discrimination statute. And if it is protected activity, you cannot retaliate against an employee for conducting self-help to basically gather the information that helps support that they have a claim of discrimination or retaliation. In order to have an employee to have that protection, however, the employee's actions have to be reasonable in the totality of the circumstances. So what do we mean by that? Well, what we mean by that is the court is going to take a flexible approach and look at all the circumstances of the situation under which the employee may have taken and copied documents and or given them to their employee or even disseminated them. And it's a balanced approach that the court's going to take. And what the court is going to be looking at is balancing the employer's legitimate need to maintain an orderly workplace, who has access to what documents, that they're kept in the office, they're not disseminated freely, and protect their, obviously, confidential business and client information. And balance that against the compelling need of the employee to be safeguarded against retaliatory or discriminatory actions. So what the courts will generally do is look at 7 factors. One is they're going to want to inquire as to how did the employee come to possession of the document. If the employee was rooting around in the human resource file cabinet, which they would normally not have access to, that would be a problem for the employee. And that would be a benefit to the employer to be able to argue that the self-help was not allowed. Generally, the employee, if the employee has general access to documents in the normal course of their job as part of their job, then that is going to be generally looked at as fine by the court. The next factor the court's going to do is balance what's the relevance of the documents to the employee's legal action, i.e., are there emails from the supervisor making discriminatory comments to them versus is it a copy of the spreadsheet showing all the customers they have and the details of their of the sales transaction that you had with those. That's not necessarily at all related to the employee's action. And they're going to balance the relevance of those documents against, again, what's the disruption to the employer's business. So it's always a continually balanced approach. The third factor is the court's going to look at is what's the strength of the employee's reason for copying the document instead of simply describing it to the lawyer or just the government person or identifying its existence. There's an email such and such a date. There's a file that has this label on it that's got the information in it. So, you know, could you have done something in that capacity rather than copying the documents? Next factor is what did the employee do with the document? Did it disseminate it socially on Facebook, or did it just give it to the attorney? And again, that's a key factor. Did it just give it to the government official, or did it, again, shout from the rooftops and say, you know, here's what's going on, look at this, and throw out the copies of the papers all over the place? The next factor is what's the nature and content of the document that the employee copied or took, and effectively, what is the interest of the employer in keeping the document confidential? If it's an email and exchange, that may be less of a disruption than obviously if it's an actual document that is the trade secret, has the formula on it. And what the relevance might that be to a claim of discrimination or retaliation, I couldn't think of right now, but there could be an instance where, for some reason, that was important to be disclosed to the attorney or government official. The next factor is whether the employee's disclosure violated a company policy on privacy or confidentiality. And then the last factor is kind of the tipping of the balance factor. What a court will do is consider the broad remedial purpose of the statute prohibiting discrimination and the effect of the decision on the balance of the rights between the employers and the employees. So after you go through the 6 factors, then you finally look at this factor and say, where does this balance put me, and does it tip it towards the employee or does it tip it towards the employer?